All right, joining us on the show, we have Dr. Abhishek Manu Singhvi, a four-time sitting MP, member CWC, eminent jurist and senior national spokesperson of the Congress. But most importantly, he is somebody who's going to help us understand what this case really was about as senior advocate for Arvind Kejriwal. Thank you very much, sir, for speaking to us here. First up, the argument being given today is that any celebrations by the Aam Aadmi Party, Mr. Kejriwal, are premature because already this order has been challenged in a higher court. What would you say to that?
Well, first of all, I have fond reminiscences and a sense of personal satisfaction because this liquor policy was challenged right in the beginning in 21-22 by writ petitioners on the civil side, not for not implementing it, for staying it. And from then I've been appearing, and of course through the criminal journey of the Manish Sisodia, Sanjay Singhs, Arvind Kejriwals, etc. Though I was not involved in this particular case, but it's been a continuum. So I think it's a great judgment, a matter of great courage and boldness in the current ambience of intimidation and fear. But to your specific question, I'm amused by this use of the phrase of premature celebrations. A person, the prosecuting agency, which has lost so badly that a judge does not consider it a fit case to answer a charge. Remember, it's not an acquittal, it's not a conviction after evidence, it's a discharge, are now saying that this is premature. Let me also remind them that there are umpteen judgments, and more recently, very recently, judgments which say that once a person is discharged, you of course can appeal, you should appeal, you have a right to appeal, but a stay of a discharge order should almost never be given. That's the law. So I think people who are accused, who've gone through a process which itself is the punishment, who've been arrested in high constitutional position, who've been humiliated, there is not a premature celebration. I think it's a vindication of their rights as accused.
Now, in the same case, the Delhi High Court on two occasions, in May 2023 and May 2024, had denied bail to Mr. Manish Sisodia and had called the case a grave misuse of power. Is there any chance that the High Court could again take an unfavourable view in the case of Mr. Sisodia, Mr. Kejriwal, given that the facts remain the same?
Well, of course, all courts can take different views. And if this High Court takes a different view, it's also entirely possible that the Supreme Court may take yet another different view from that of the High Court. But that's not the point at all. The point is that you are mentioning bails. By the way, the bails you are mentioning, most of them were reversed. I had the privilege of appearing for Sisodia, Sanjay Singh, Kejriwal. And the bail orders you are mentioning, which were denial of bail, were in fact converted into grant of bail orders. But this is not about bail. At the stage of framing charges, Padmaja, the judge has to decide whether there is sufficient credible material even to frame charge, on the basis of which charge I will then lead evidence to show that Padmaja is guilty. Now, if the judge finds that the nature of the charge against Padmaja is such that she has no charge to answer, that there is not sufficient material to frame a charge, it means that the entire thing was a hollow chimera, an illusion from the beginning. And it also tells you, Padmana, that the discipline of law, the principle of law, the gravity of law is often overwhelmed by screaming headlines, selective and strategic leakages, and an ambience created to suggest that there's nothing at all. But now when the hard light of law is cast, so today the case legally is at an end. It doesn't exist in the eye of law. You go in appeal, it will very rarely be stayed, is the law. It should not be stayed. But then it can go on. Ultimately, in a final order, not an interim stay order, in a final order, the High Court, as a superior court, can reverse. But I think today it's a very, very remarkable and a very substantive victory. Let me add a few more things. Perhaps you have not read all the paras. It's a 600-page judgment. And obviously, nobody expected to know the paras. But let me give you an example of para 469. The court records that, the court says that, I quote now, the case records reflect a premeditated and choreographed exercise with roles retrospectively assigned to suit a preconceived narrative, and finds it particularly disturbing that public servants were prosecuted solely on inadmissible hearsay attributed to an approver despite no material against them. Unquote. Then again, Padmaja, very interesting. A new design, a new methodology was created for this case, which has never happened in Indian criminal history earlier. So step one, you have the main accused, let's say Kejriwal, Sisodia, etc. Step two, you have other co-accused, ABC, the Maguntas and the various names you know. Step three, those accused are put in jail first. They are, step four, denied bail by vociferously opposing their bail. Step five, suddenly one fine morning they turn approver. Step six, magically the next day they get bail. Step 7, their evidence is recorded only against the principal accused, Kejriwal or Sisodia, etc., etc. Now, this modus operandi has come in for very specific criticism by the court, saying that this kind of a narrative, and by the way, the Supreme Court has been saying, and the Privy Council, in fact, said decades, almost a century ago, that the lowest and the most poorest form of evidence is the evidence of an approver. Because an approver is a squealer for a self-interest, which has a vested interest, for him to squeal. Now, entire basis of this chimera, this house of cards, were approver evidences not backed by circumstantial, additional, external evidence. It is possible that you are an approver, you are speaking in your self-interest, but I have additional circumstantial evidence to show that there was this, that, or the other on the scene of crime. Then you can use, but here there is no additional circumstantial evidence. And the court has also gone and said that, look, this went through a year of institutional, multi-layered policy decision-making over 10 levels. 1 year, I think it's 11 months or something, over 10 levels, including and culminating in the LG's office. So it's not the knee-jerk dictatorial will of one person. So an institutional policy decision cannot be criminalized or weaponized. And the court rightly says, failure of a policy is not criminal. Making of larger profit is not illegal. And the only ground on which Kejriwal is roped in, by the way, Kejriwal is not part of the entire decision-making process, etc. He is roped in on using adjectives which the court has castigated. Kingpin, grand conspirator, the central controlling, overarching control person. They are the words of the court as argued by the prosecutor. So, adjectives don't make for guilt. Adjectives don't make for, conviction. And that is why this case has fallen flat on its ground.
But then help me understand, how is it that in 2024, 2023, you had lower courts saying, in fact, you had the High Court saying that there is no case made out for grant of bail. You are saying that there was a grave misuse of power and breach of public trust by people like Mr. Manish Sisodia, and then cut to 2 years later, the court says there is no case to proceed on. How is it that the same set of evidences are called gross misuse of power and breach of public trust?
You are making 2 or 3 fundamental mistakes, and you can't be faulted because you're not a lawyer. Mistake number 1, you're talking of bail orders.
Yes.
Bail orders are based on a very, very superficial prima facie view of the matter. So they have nothing to do with the trial court judgment which has come today, which goes into great detail on the evidence. They don't go into evidence. In fact, the findings or the observations of bail order 1 will not even affect and bind a judge in a second bail order. So bail is a very inapposite example to give. Second error, those bail orders which in any case don't bind, which in any case are certainly not any trial-based orders, but themselves reversed by the Supreme Court. It's those very orders which you're talking about where I appear in the Supreme Court and we got bail.
But sir, respectfully, in the case of Mr. Sisodia, the Supreme Court simply said that he had been in jail too long. They did not comment on the merits of the case. They gave him bail because he'd been in jail too long.
Then that's not the way you separate a bail order. The High Court denied him bail, saying you can't go out, despite him being there for long. The Supreme Court said you go out. So how can you rely on bail orders of the High Court which have been reversed by the Supreme Court?
Okay.
There's no question.
Then what do we make, sir, of the CAG report? For example, in January 2025, there was a CAG report which said that revenue loss of 2,026 crores had been incurred to the exchequer. It also spoke of how there were significant lapses, there were policy deviations, and there were violations in issuing licenses, and finally said that the policy failed to achieve its intended goals. But 2,000 crore plus loss.
That the problem is that when you get into premeditated political games, then you start taking things which have to be yet tested as conclusive final evidence. Let me ask you to step back a little bit. You know how much hullabaloo went on when the CWG games were on? And a lot of people lost their jobs, careers, and later on their lives on a so-called Shunglu Committee report. You remember that?
Yes.
That's a CAG report. A former CAG authored it. Do you know that that whole thing was squashed ultimately when the dust had settled down and time had passed? A CAG report, forget a CAG report, a Commission of Inquiry under the statutes report, none of them bind any criminal conviction or judge. They have to be independently proved. So suppose a Commission of Inquiry finds that you, Padmaja, were at spot X on day Y at time Z. That is produced straight away in the trial court and said, now on that basis of that finding, you please convict Padmaja. The law is totally different. The trial court has to independently get proof, independent of that report. That report can be evidence. But he has to independently examine that evidence or ask for more evidence, saying, I will not convict only because some Commission of Inquiry said so, or Shunglu said so, or CAG said so. So these are all inversions and complete distortions of established criminal law principles. And the biggest one I've given you, get an approver. The problem with this case is you wanted to catch politically. You wanted to embarrass and humiliate politically. So you relied almost entirely on approver reports. That's the weakness of this case, which is why it's fallen flat on its face.
Okay, final question I'm going to ask you, Dr. Singhvi, is a political one. It's ironic that you're saying that this case does not exist. The Congress party, on the other hand, is saying that there was a very strong case. They were the first complainants. And the only reason that Mr. Kejriwal, in this case, has been discharged is because there's a fixed match with the BJP. What do we believe?
No, let me tell you. I'll tell you. I am talking purely as a counsel. I've been appearing in this case for years. I'm not talking politically. I'm giving you the legal answers. The legal answer is that it's based on now. Politically, there is a battle going out there. There's a three-part part. That's not the point I'm making at all. I appeared. I'm not appearing now. I've been appearing in this liquor policy case in 2021 onwards. So I am obliged to give you a fair answer in law. I'm not talking politics.
And legally, you think that this case is a non-starter? It's a non-starter of a case?
Well, discharge means, in law, the word discharge is something very special. It means that the case need not go to trial. It means that you need not frame charges which Padmaja has to answer. It means that on those charges which Padmaja would have had to answer, no evidence needs to be led because the charges don't stand. So as of today, it doesn't exist factually or legally. After a discharge, no case exists.
All right.
Now it's possible for the High Court, after hearing it for fully and finally, to reverse the order of the trial court. Just as it is possible for Supreme Court to reverse the High Court order. But I have also given you judgments, which I don't want to bore you with the details, which say that in the interim, while the High Court is seized of the matter, 99.999% discharge orders should not be stayed.
All right, Dr. Singhvi, thank you very much for speaking to us. And if indeed that overturning happens from the High Court, we'll come back right to you. For the time being,
thank you
for joining us
on
the Buck Stops here.
Thank you.